Judge, we have a stipulation with regard to the violation and with regard to disposition.
Okay, let's get all that on the record and see where we go with that. So we are shifting to our first four positions on the revocation calendar, all of which belong to Mr. Green, who is in court. Good afternoon, sir. With his lawyer, Mr. Melnick. Ms. Simpson, you may have shared before, but I don't have it in front of me, the amount of time remaining for Mr. Green on his different cases.
The balance for all four cases are 5 years, 4 months.
So he has the identical clock running on all four cases. 5 years, 4 months. All right. So Mr. Green, you've got a little under 5.5 years remaining on your probation across these four cases. Some pretty charges and some less serious charges, all pretty old. I inherited those cases. Judge Downs was the judge who sentenced you to whatever you got. She has since retired. Her docket went to another judge, me. And in January of this year, probation came before me to say, Mr. Green's gotten in trouble again. Specifically, in November of last year, you were arrested in Clayton County by one or more of the officers here for possession of methamphetamine with intent to distribute, cocaine with intent to distribute, a gun, it's a problem, and maybe obstruction, and then more drugs. Oh, a whole bunch of charges. They can't even list them all. There's so many. It says 15 total charges. You were arrested for those things in Clayton County. Getting arrested is evidence of a violation of the law that gets you sideways with probation, and so we are together. And it sounds like Mr. Melnick, Mr. Green is stipulating to his arrests. So yes, these things happened, meaning the arrest occurred, and that's a violation of his probation. You and Ms. Dilligard have been going back and forth about what the consequences should be. Before we get into that, what is the status of the Clayton charges?
Unindicted.
Unindicted. Pending. Is Mr. Green out on bond from those?
He has a bond, but he has not posted that bond, Judge. So he's been in continuous custody since November 19th of last year.
Okay. And this warrant got put on him. He came here. Why post the bond? You can't go anywhere anyway.
He's here on a production order from Clayton County.
Okay. Got it. And what is it that you are recommending I do in light of those stipulations, Mr. Melnick?
Your Honor, based on the stipulation, Ms. Dilligard and I have agreed that it would be appropriate to revoke 2 years of his probation, giving him credit for the time that he has served since November the 19th of last year.
Okay. So, Ms. Dilligard, if I sentence Mr. Green to a revocation of more than 6 months, credit for time served isn't given. And so if I am to agree that a 2-year stint in custody makes sense, I'll do the math, but it would be more like 1 year and 6 months that I revoke from today, because 6 months of that 2 years has already ticked by, 6 months-ish. So I just want you to understand, I don't know how you need to report it or what you were envisioning, but if I revoke 2 years, if that's what my revocation order says, and I write credit for time served, Department of Corrections will cross out credit for time served, and Mr. Green will do 2 years from today. Now it's parolable. He might get out in less than 2 years, but his max out date would be May 7th of 2027. And I don't have an issue with that. But I just want you to know that if I go along with what's recommended, then what I'll be revoking is 1.5 years, not because I think 2 years overshoots it, but because what you're saying by saying credit for time served is that you think 2 years of time from the day of his arrest is the appropriate revocation.
Yes, Judge. And I was able to confirm, he showed me his incarceration date from Clayton County. And so I think the original recommendation from probation was to revoke 5 years. I told Mr. Melnick that I wouldn't do no less than 2 years.
Okay. Was 5 years the original recommendation? Yes. Tell me, Ms. Dilligard, other than not putting the officers through the ringer of having to testify, why do you think that 2 years, given the number and seriousness of the offenses for which Mr. Green was on probation, why you think 2 years it's not unreasonable, but why is 2 years more reasonable than 5 or 4 or 3?
Judge, I based that off of his previous revocation back in 2023, similar firearm drug arrest. He was revoked 210 days, and I felt as though that didn't teach him a lesson, so I thought that to double that may do the job. And so that's kind of where the two came from.
Okay, that's an interesting nugget. So in 2023, I guess I can look one of these cases up. Let's look up the most recent one, 10 SC. I'm not quite sure why these cases are with me. Maybe the oldest one is Judge Downs, because the position 4 was a LRB case, which means it's a Schwal case now.
The other two were just Schwal, and I don't know how.
Okay.
We were dealing with the last revocation. I'm sorry, I did not mean to interrupt. Basically, for the sake of efficiency, everything got combined into your program.
It makes sense. I'm not worried about Judge Schwal coming after me saying, "How dare you handle my revocation?" It just threw me off because it said an LRB case.
Well, funny enough, originally they were on Judge Schwal's calendar, or the positions 3 and 4 were on his calendar to handle, and then we ended up with.
Well, if Mr. Melnick had been retained by Mr. Green, he's going to do exactly what he did, which is try to get them all in one place. And they ought to go to the oldest case, which would be the 08, which is Judge Downs, which is now me. So we're in the right place. So in September of 23, so we met before, revoked you for 210 days for similar sounding stuff. What happened with that case?
It's still unresolved, Judge.
Is that also a Clayton County case?
No, it's pending in the non-complex division.
It's been indicted.
It has been indicted, yes.
Huh. Okay. So while on probation for these 4 cases, you picked up a set of charges kind of similar to the Clayton case. It's been indicted, it's pending, and you got revoked for 210 days. And I guess bonded out, and then we have this situation. Was there anything about your work with the officers involved that made you think, we need to work this out rather than have an evidentiary hearing?
No, Judge. My understanding after speaking with the officers and reading the reports, this defendant fled the scene, but the officers did extensive work to identify him using all kinds of investigative tools. And so I felt strongly about the case, to answer your question.
Okay, got it.
Well, I will add that the drugs in the car, to counsel's point, there was an equal access argument for that. However, the firearm that was that he's charged with was on his person when he fled. So.
Okay, so there was more than one person in the car.
Yes.
I'm not going to dive into the facts he stipulated, but at least it's a group situation in the car. But then either the officers see him discard a firearm, or when they get to him, he has a firearm.
Yeah, they see him discard it. They
Okay. All right, Mr. Green, anything you want to add? How old are you? 37. Okay. Well, Mr. Green, you're going to need to figure out, it's not an easy thing to do. I think you've got family here on your behalf, how to chart a different course, because you keep getting mixed up in whether it's your idea or you're just riding with people whose idea it is. But drugs and guns and you getting together in the same space, it's just going to leave a bigger and bigger mark.
It's my off around with the wrong person.
Okay, I hear you. And I'm not, you as a person, you know, we all have our own issues and you're working through stuff, but you are now wise enough in the ways of the world that my guess is you weren't surprised that there were drugs in the car. I don't know how surprised you could be with the gun you had on you, but I am confident you knew that wasn't the right place to be. Circumstances are such that you were there. It's not a blame game here. Life is complicated. That may have been, I can make money doing this and I got people I need to support, etc. One way you can't support them is by getting locked up again and again. And these are going to leave bigger marks each time. I don't know what Clayton's going to do. They tend to play less gently than we do. And these charges are pending down there. I'm going to revoke 3 years of your probation, and then reinstate the balance. on 2 of the cases, and terminate your probation on 2 of the cases. I am terminating your probation on the 08 SC case and the 09 SC case, but I'll leave the probation running on the 210 SC cases. Clayton may choose to wrap things up down there. In light of this, I suspect if Mr. Melnick can get people's attention in non-complex, they certainly would resolve your Fulton case in light of this revocation, which is often how these things are supposed to work. But my message to you is at age 40, which is the oldest you'll be when you get out, you'll likely get out before then, just figure out a different way to roll, because you'll be in front of a different judge next time. And that judge might say, I don't understand why it should be a day less than 5 years and 4 months. You won't have that much time left, but you've got these other cases to work through. So I hope it turns out differently for you in the future.
Judge, may I be heard quick?
You may.
So, Your Honor, what happened with this incident that led to his arrest in Clayton County? He wasn't the driver, he was a passenger in the vehicle. And the allegation is that he ran from the scene and that the firearm was found in the trail where they tracked after. And all the drugs were found in the car, not in Mr. Green's possession. I mean, I did come to him today with the agreement of 2 years, and that was what he was expecting. Do you mind if I talk to him real quick, since that's not what he's getting here right now?
Sure, you can certainly talk to him. A few things. 1, this isn't a final plea type situation. 2, I appreciate your recitation of the facts. And I'm fine because we've got the officers right here to do the hearing. And if we do the hearing and it sounds less good for Mr. Green than what you described, then we have the original recommendation from probation that's on the table. And 3, just make sure you also explain that this remains fully parolable, et cetera. Okay.
All right, Judge. Thank you.
That was the conversation?
Yeah.
All right. Good conversation. Mr. Green, I hope when we meet each other again, it's in better circumstances. And don't handle it like Mr. Alexander is handling it. I appreciate both of you being here. It was necessary. It got resolved without you testifying. You may need a subpoena signed or something by Ms. Dilligard, but we always appreciate folks coming from other jurisdictions. Not always easy to pull off.